My grandfather and great-grandfather started Junction Auto in 1931.
If you want to pay more, that's your business. If you want to pay less, that's my business.
In coming to a fair sentence in this case, some salient considerations have occurred to this court. That being, first off, that you, Mr. Field, are not a stranger to crime. You do have a history, a record, one of which involved some child pornography. At the time of this offense, you were about 30 years old, and the victim was 14, and you knew it. The matter of your discussions with Ravenwood, I think it's a little late in the day for that. At the time of the pre-sentence investigation, there had been no effort made to seek any kind of treatment for what happened in this case. From my review of the pre-sentence investigation, I do find that the defendant's expressions of remorse appear to this court to be shallow. There appears to be little empathy for the effect on the victim. That effect we do not know. But I think we can presume that a 14-year-old, under these circumstances, is going to be severely affected. This was a child. This was a sex offense. Of all people, with an associate's degree in psychology, Mr. Field may be better equipped to tell us than we are to figure out on our own the effect on a 14-year-old of what happened here. But what's truly telling to this court is that this wasn't an impulsive, impromptu occurrence, but it was an event that was preceded by texting between the minor victim and Mr. Field, who out-aged her by about 16 years. That clearly led up to this. And, in fact, you bought the condoms for her to use during this rendezvous. The defendant was in a position to trust with respect to the victim, who was the sister of the defendant's fiancee with whom he was residing, and who is the mother of three of his children, all minors, all living under the same roof where this occurred. So what should have been a relationship where this 14-year-old should have trusted, been able to trust Mr. Field to protect her, to watch out for her, to caution her, to guide her. What should have been closer to a parent-child relationship turned into a sexual encounter. Granted, Mr. Field has not been to prison before, and so there is a check mark in his column that he's never been to prison before or done anything to fetch a prison sentence. On the other hand, I find that the nature of this offense is so despicable that more than the minimum is called for. 14-year-old can't be the cause of an incident like this with a 30-year-old. They're capable of consenting. The law recognizes that. And I find that Mr. Field has, at least in his statements to the probation department, has sought to shift or distract attention to the victim's role in this as being a contributing factor when what reaction there should be is one of total remorse and empathy for a 14-year-old who now has this in her past and is still the sister of the fiancé of the defendant. All things considered, it's my determination that the defendant's not amenable to community control, that a prison sentence is in order. And so, in your case, Mr. Field, I'm imposing a prison sentence of 3 years with credit for any jail time served, 3 years in a state of Ohio penal institution. I'm advising